This morning, at 8:47 a.m. Eastern Time, United States Marshals arrived at Mar-a-Lago with a court-ordered writ of execution to begin asset seizure proceedings. 3 federal marshals, a team of professional appraisers, local law enforcement backup, all there to enforce $550 million in unpaid civil judgments. Before you assume this is unprecedented political targeting, let me explain what a writ of execution actually is. It's a standard legal document issued by courts when someone loses a civil case, gets ordered to pay a judgment, exhausts all appeals, and still doesn't pay. At that point, the court authorizes law enforcement to seize assets and sell them to satisfy the debt. Here's where we are. February 2024. A New York judge entered a civil fraud judgment for $355 million. March 2024. A separate defamation judgment for $83 million. Combined total with 9 months of interest, $512 million. It grows by $130,000 every single day. Appeals were filed, appeals were denied. The judgments are final. And when civil judgments become final and the defendant doesn't pay, this is what the law requires: asset seizure. Let me walk you through the timeline that brought federal marshals to the property this morning. I'll be tracking this seizure process through completion, every filing, every asset valuation. If you want to follow the facts without the cable news spin, subscribe. February 16th, 2024. Judge Engoron enters judgment. $355 million in fraudulent gains must be returned, plus interest at 9% annually. March 8th. Federal jury awards $83.3 million in the Carroll defamation case. Combined total, $438 million owed. Within days, appeals are filed. But in New York, when you appeal a civil judgment, you must post a bond, typically 110% of the judgment. For $438 million in judgments, the bond requirement was $480 million. April 2024. The deadline passes. He posts $91 million for Carroll only. For the fraud judgment, nothing. He asks the court to waive the bond requirement. The court denies the waiver. The law is clear. Post bond or the judgment can be enforced immediately. June. Judgment creditors file motions to authorize asset seizure. August 15th. The court rules. Without proper bonds, enforcement may begin. Asset discovery is authorized. September through October. Creditors subpoena banks and property records. They identify assets: Mar-a-Lago, Trump Tower, golf courses, bank accounts. October 9th. The appellate division denies the fraud judgment appeal. No more state appeals available. October 23rd. Carroll judgment appeal deadline passes. No Supreme Court appeal filed. Both judgments are final. Total with interest, $512 million. November 1st. Creditors file for writs of execution in Florida and New York. November 7th. Florida court issues the writ for Mar-a-Lago. This morning, U.S. Marshals execute the writ. 9 months from judgment to seizure. At every step, post bond, pay, negotiate, liquidate voluntarily, the choice was delay. And delay has a cost. The debt grew by $41 million during those 9 months. Now let me show you what the marshals can actually seize under the law. Florida law provides homestead exemption. Your primary residence cannot be seized to satisfy civil judgments. But is Mar-a-Lago a primary residence? The property is legally classified as a private club. It operates as a business with $200,000 initiation fees and $14,000 annual dues. It hosts events and weddings. In 1993, he signed an agreement with Palm Beach converting Mar-a-Lago from a private residence to a private club. That agreement restricts living there to 21 days per year. Florida courts have ruled, if a property operates as a business, it's not protected by homestead exemption, even if the owner lives there part-time. Mar-a-Lago is a club that happens to have residential space. Under Florida precedent, That likely means no homestead protection. What can be seized? First, business assets. Club furniture, fixtures, kitchen equipment, vehicles, golf carts, inventory. All seizable. Second, personal property on commercial premises. Artwork in ballrooms and dining rooms. Antique furniture in common areas. If it's on commercial property, it's seizable. Reports suggest paintings worth millions displayed throughout Mar-a-Lago. If they're in club areas, they're seizable assets. Third, the real property itself, land and buildings. This requires additional proceedings and takes months or years. But if the court determines no homestead protection applies, the entire property could be sold. Here's the irony. For years, he claimed Mar-a-Lago was worth over $1 billion. But the fraud judgment found he systematically inflated values. Court-appointed monitors estimate actual value between 200 and 400 million. Independent appraisers will determine real value. The process is methodical. Marshals catalog everything, room by room. Professional appraisers establish fair market value. Items go to court-supervised auctions. But even if every item sells at fair value for 20 million total, that's 4% of the judgment. Where does the other 492 million come from? Mar-a-Lago isn't the only target. Judgment creditors filed asset discovery in 4 states, identifying properties, bank accounts, and revenue streams. Trump Tower penthouse in Manhattan. He claims 200 million value. Analysts estimate 120 to 180 million. Not protected by homestead. He claims Florida residency. Seizable. Golf courses in Bedminster, Turnberry, Dunebeg. Financial disclosures value them around 400 million combined. All commercial operations. All seizable. Licensing deals generating 5 to 20 million annually. Revenue can be seized through court orders redirecting payments to creditors. Bank accounts at multiple institutions. Asset discovery subpoenaed JP Morgan Chase, Deutsche Bank, Capital One. If there are tens of millions liquid, those accounts can be frozen and transferred. When collecting a judgment this large, you cast a wide net. You prioritize based on value and liquidity. Bank accounts are maximally liquid, freeze and transfer in days. Licensing revenue is moderately liquid, redirect future payments in weeks. Real estate is valuable, but illiquid. Marketing and selling takes months or years. The strategy: hit liquid assets first to stop the bleeding from daily interest, then pursue real estate for bulk recovery. The judgment accrues 46 million per year in interest, 4 million per month, 134,000 daily. Every day this drags out, the debt grows. His legal team will challenge everything: appraisals, seizures, valuations. But the appeals are over. The judgments are final. Every challenge now is about enforcement details, not whether enforcement happens. Let me know in the comments. Do you think the full judgment gets collected through asset sales? Or does this drag out for years? I'm curious what you're seeing. Now let me show you what happened when marshals entered the property. This morning at 8:47, 3 U.S. Marshals, 4 appraisers, and 2 sheriff's deputies arrived at Mar-a-Lago's main gate. The lead marshal carried the court order authorizing entry to catalog and appraise assets. Security refused entry initially. Standard procedure when law enforcement arrives unexpectedly. The marshal presented the writ. Security called supervisors. The supervisor called the property manager. The manager called lawyers. For 90 minutes, there was a standoff while lawyers reviewed the writ. The lawyers checked. Is it valid? Properly issued? Any pending stays blocking enforcement? At 10:15 a.m., the lawyers concluded. The writ is valid, properly issued, no stays in effect. Florida law requires access. The lawyers told security, let them in. At 10:17, the gates opened. The appraisal team began in public club areas, the ballroom, dining room, corridors and common spaces. They photographed artwork, measured furniture, checked manufacturer labels on chandeliers, examined antiques. One witness saw an appraiser photographing a large landscape painting in the ballroom, taking notes about the artist and period. Another reported the team measuring an antique sideboard, checking for maker's marks. Clinical, professional, by the book. The marshals provided security, but didn't participate in appraisals. Their role? Ensure the appraisers could work without interference. By 1:30 p.m., they'd cataloged public areas. They did not enter private residential spaces. Those require additional court authorization. The team left around 2 p.m. 6 hours on site. Tomorrow, appraisers begin valuations. They'll research comparable sales, check auction records, consult databases. By next week, they submit preliminary valuations to the court, listing each item with estimated fair market value. Then creditors can request court authorization for auctions. For someone who's operated for decades, assuming wealth provides immunity from legal consequences, having federal law enforcement on your property, cataloging your possessions, represents forced confrontation with reality. The law doesn't negotiate. The writ was valid. Entry was required. When the lawyers confirmed the marshals had legal authority, there was no option except compliance. That's accountability. Physical, immediate, undeniable. Cataloging continues tomorrow at Trump Tower. Next week, the New Jersey golf courses. The system is functioning. Slowly, methodically, but functioning. This case sets 3 precedents affecting civil judgments for decades. First, wealth does not create immunity from judgment enforcement. For decades, wealthy defendants used a standard playbook. File appeals. Hide assets in corporate structures. Move money offshore. Delay until creditors run out of resources and settle for pennies. O.J. Simpson's civil judgment. The Goldman family pursued assets for 25 years, eventually collecting 30 of $33.5 million. Bernie Madoff victims. Marshals seized everything. His watch, his wife's jewelry, a signed baseball, furniture. The message: you pay voluntarily or through seizure. Rudy Giuliani faces $148 million in defamation judgments. Creditors are pursuing his apartments, his Mercedes, his World Series rings. Similar process, similar resistance. This case demonstrates that when creditors have resources and determination, and courts maintain enforcement authority, the system provides a path to collect even massive judgments. Not guaranteed, not fast, but real. Second, civil consequences can achieve accountability when criminal prosecution doesn't. The fraud judgment was civil, not criminal. No prison. But civil judgments carry powerful tools. Asset seizure. Business dissolution. He's barred from operating businesses in New York for 3 years. Lifetime financial monitoring. These are accountability mechanisms when criminal prosecution isn't available or doesn't succeed. Criminal cases require proof beyond reasonable doubt. Civil cases require preponderance of evidence, a much lower bar. When criminal prosecution faces obstacles, civil judgments offer alternative accountability. Third, visible enforcement creates public accountability. Legal filings are invisible to most Americans. Marshals arriving at Mar-a-Lago creates an image that penetrates public consciousness. It makes abstract judgments concrete. It demonstrates the legal system can function, even when the defendant is wealthy and politically connected. That visibility matters. It affects public perception of equal justice. It influences whether other creditors believe enforcement is possible. When people see marshals executing a writ at a property owned by someone who held the highest office, it signals the law doesn't stop at a certain wealth threshold. The pattern that determines success isn't judgment size or defendant wealth. It's creditor persistence and court willingness to use enforcement tools. When creditors give up, the system fails. When courts grant endless delays, the system fails. But when creditors persist and courts maintain schedules and use available tools, the system can work. If you've been frustrated watching powerful people dodge accountability through endless delays, this is what it looks like when creditors don't settle, when they pursue every legal channel, when the system provides tools to actually collect. Not guaranteed success, but a demonstration the path exists. Today, they used it. I'm tracking 3 developments over the next 2 weeks that will determine whether this produces payment or more legal warfare. First, appraisal valuations. Appraisers submit preliminary valuations by Friday, November 22nd, 8 days from now. The total tells us, are Mar-a-Lago assets sufficient to make a meaningful dent, or do creditors need to immediately shift focus elsewhere? If preliminary valuation is 20 to 30 million, that's 4 to 6% of the judgment, meaningful but insufficient. If it's 80 to 100 million, creditors might prioritize Mar-a-Lago auctions first. If it's low, expect immediate action on Trump Tower assets. I'm watching for that filing November 22nd. Second, legal countermoves. His team will file something. What they file reveals what they fear. Emergency motion to halt seizure? They're trying to stop the entire process. Motion challenging specific asset classifications? Fighting item by item. Motion challenging appraisers before valuations are submitted? Worried about high valuations. If they challenge Mar-a-Lago's business classification, arguing homestead protection,